All rise. The Honorables, the presiding Chief Judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you. Let's see here. Well, good morning and welcome to the Court of Appeals in person for my first time being in here since pre-pandemic, so I'm pretty excited. Your panel today, I'm Judge Donna Stroud. On my right, we have Judge Chris Dillon. On my left, Judge John Tyson. We have two cases for argument today, and our first case, Blackwell v. North Carolina Department of Public Instruction, and it looks like everyone is in place and ready to proceed with that argument. So, let's see. I got to figure out where to put everything up here with the panels. Let's see. All right, yes, and you can go, the appellant may proceed.
Can I proceed?
Yes.
All right, good morning. Again, I'm Tom Raymer. I represent Ms. Carmela Blackwell and her family in this matter, and like Chief Judge Stroud, this is my first time to be back live. I did a federal court appearance live in person, but absent that, that's the only two live appearances in 2 years, so it's refreshing to be here, in spite of all of our unique surroundings. I would like to reserve 7 minutes for rebuttal if I can.
Okay.
And I do have the privilege of representing and presenting Ms. Carmela Blackwell in this matter. Ms. Blackwell was a teacher with in excess of 10 years of experience. I can tell you, as a gray-haired old man who's been married to a teacher for 37 years, a special ed teacher for 37 years, not only do I have the highest respect for teachers, but out of my own, my wife's desires, try to respect and take care of the teachers. This case is, I believe, a case of first impression in that are requesting a ruling for a lump sum payment under General Statute 9744 for an individual who has been determined to be permanently and totally disabled. To my knowledge, there's no such case has ever been ruled upon, and so we appreciate the courts being willing to hear the matter, given the importance not only to my client, but to the bar in general. The facts are pretty undisputed. My client was a 37-year-old school teacher. She had two children, the youngest of which was 6 months old when this event happened. On April 3rd, 2013, she was attempting to save the life of a student during a brawl of about 20 or 30 students where they were trying to throw a student over the second floor railing down to the first floor. She intervened. In the process, she was kicked in the head and subsequently was diagnosed with post-concussion syndrome, seizure disorder, migraine headaches, anxiety and depression, and post-traumatic stress disorder. The seizure, she's been treated by two authorized treating physicians. This isn't a case where we have conflicting doctors or opinions on one side or the other. She's been treated by two doctors, Dr. Callahan, who's a neurologist, and Dr. Feldman from Wake Forest, who is a psychologist. They both agree, and the record and the facts from the commission are undisputed, that her stress levels trigger her migraine headaches or her seizures, which are very, very debilitating. And in this particular case, stressors from the late payment of benefits, where she didn't have her benefit money to pay bills, or she couldn't, in one case, buy her daughter a prom dress, where her payments of prescriptions aren't approved, where she's waiting to pick up her prescriptions, causes her to have seizures, and other delays in the process. And we're not saying by any means that the defendants have done anything wrong. That's just the normal process of workers' compensation. Sadly for Ms. Blackwell, those things trigger these debilitating seizures or migraine headaches that can wind up where she is literally in a room for 2 to 3 days in a dark room because she has a migraine, or she has a seizure and she has to have injections for the seizures, and she is essentially non-functional for the rest of the day. And that's sad in that her son, who is now 7 years old, 7 or 8 years old, has never known his mother to be able to function in a normal daily life. Now, her condition was found, she's been found to be permanently and totally disabled by the commission. That's not in dispute, that's not appealed. Prior to the permanent total disability determination, the defendants, because her condition was so profound, entered into consent orders, the last of which agreed to pay her family 24 hours a day of attendant care. And it is, again, some level of the level of distress this lady is in, because that goes to the issue of the unusualness of the case in the petition under 9744 for a lump sum of benefits. Both of the doctors, and again, these are in the facts, both of the doctors agreed that it would be in her best interest if the case were resolved in whole or part, as much as can be done, under 9744 to provide relief from her stressors, from her migraines, from her seizures, from her post-traumatic stress disorder. So our request, so we follow the doctor's recommendations in our efforts to provide relief to this young lady and to her family. We requested that 9744 be used to provide a lump sum payment that would afford her the resources to pay for the prescriptions when they weren't timely paid, or to have the money in her checking account if her checks were late. And those things were meant to reduce the stressors that trigger the seizures, the migraines, the post-traumatic stress disorder. When we pursued the permanent total disability determination, defendants were free to put on evidence that they felt like Ms. Blackwell was going to recover, or that she wasn't going to be permanently and totally disabled, or she was going to go back to work. But that didn't happen, and there's no evidence in the record of any of that. And again, that comes into play because under 9729, her benefits are for lifetime unless they produce evidence that she can go back to work. So they've had that chance to produce some evidence to say, hey, wait a minute, maybe it's a little premature for permanent total disability, and they didn't do that. The commission then went on and found, A, that it would be in her best interest to have a lump sum payment, B, that she had a severe head injury, brain injury, which is a requirement for permanent total disability under 9729D. And lastly, they made the determination that she is in fact permanently and totally disabled and therefore entitled to lifetime benefits under 9729D. However, when the commission then turned to the issue of the lump sum, they stated, this is conclusion of law number 3, because the plaintiff's weekly compensation may be terminated upon her death or upon showing that she is capable of returning to suitable employment, there is no statutorily determined number of installments, and thus an uncommuted value of the future installments is merely speculative. And then the commission went on to make a separate statement that said there was a necessity for a, quote, statutorily determined number of installments as with 9731 or 9738. So that even though the 9744 doesn't have that requirement, the Industrial Commission kind of wrote in the requirement that the only way you can have installments is something such as 9731 or 9738. We would contend that that ignores the fact that the legislature in creating 9729 created an award of lifetime benefits or lifetime installments. So there are installments. The commission says there's no installments. They're for her lifetime. The question then becomes, how do you value the lifetime installments? That's all. And in doing that, you look to, obviously, if it's a statutory construction case, you look to the intent of the legislature. And the plain language does not require anything more than the benefits being paid more than 6 months. It's an unusual case, and this is 9744, and the commission determines in her best interest. And all those things were met. So the commission kind of went outside of the statute itself and kind of said, we really think there's some kind of a requirement for a fixed period of installments similar to 31 or 38, and therefore we, as a matter of law, cannot rule on that. And we would contend that they erred as a matter of law in failing to do so.
Mr. Raymer, a couple of questions.
Sure.
Did you represent the client before the commission as well?
I've represented this young lady from almost the beginning of this claim.
And you mentioned that family members are providing attendant care,
Yes, sir, they are.
and they're being compensated for that.
They are, in fact. And again, the defendants, the defendants have done a good job of providing the benefits. We had an issue with with the dog, but that's been resolved.
Did you, so her two children are home with her husband?
One child is now grown and in college. The other child, again, after this occurred, was 6 months old. And so until we got the consent order for the attendant care, I think her mother moved in with them. And now the care is being provided primarily by mother-in-law, husband, daughter when she's home, and I think there's a friend.
Did, and your client now is what, 44, 45?
Yes, sir.
I noticed the record reflects she did not testify before the IC.
She did not. We had a statement from Dr. Feldman that indicated it would not be in her best interest and would actually trigger her to have seizures if she did testify. Actually, she testified at the first hearing, at which point in time she had a seizure outside of the courtroom, had to have an injection, so that's why she didn't testify.
Is she able to communicate her wishes?
Yes.
So as far as an affidavit or anything like that, was there anything in the record that reflected this is something she wanted for herself?
Other than the fact that, she's authorized me to request a lump sum payment. Her husband testified at the hearing that she has requested a lump sum payment for the same reason, that being to provide resources to kind of bridge the gaps when these hiccups occur and to minimize her stress.
Let me ask you this. If we were to reverse the Industrial Commission and authorize a lump sum, and that was paid out, what would happen when that is exhausted and she continues in the condition she's in?
Well, first of all, I think it's under 9745 or 46. There is a provision where the commission can have the funds paid to a trustee. There's specific thing where if a lump sum is paid, that can be done. So, number one, there's a mechanism in place that the commission, in its discretion, could exercise its right to have those funds simply paid. It would simply be a matter of they would have the access to that on a more immediate basis.
And what would happen once those funds were exhausted?
Well, if a trustee administer similar to a weekly payment or a monthly payment schedule, then presumably they wouldn't be exhausted.
Are you feeling that maybe if she had a lump sum, she could invest those at a higher rate of return than maybe what she's getting now?
She could. I mean, clearly, it would be an uncommuted lump sum. So, at rates of return today, with some professional guidance, they could do that. They could pay off their house and have no mortgage payment, which clearly, under the only other reported case under 9744, Lee versus Harris Paving, that's what the widow did, is she wanted to pay off her mortgage and stabilize her financial future, and the court authorized that.
Is she also receiving Social Security disability benefits?
Yes, sir, she is.
Full?
Yes, sir.
And is her children receiving benefits as well?
Her youngest child should be, because they're under the age of 18.
And the prognosis for any recovery, that she might have some beneficial?
My understanding, the best the doctors could testify, is that we can try to minimize her stress and basically increase her quality of life, but that there is no expectation at this point in time, based on the head injury or the brain injury, that she would recover anyway. And again, I think this goes to what the statutes, whether that be 9729 or 9744, provide for, which is the defendants have the opportunity to provide that kind of evidence. In this case, there is no evidence of that. I mean, I think that's a great question, obviously, but there's no evidence of that.
Is your client ambulatory?
I'm sorry?
Is she ambulatory?
Oh, yes, sir. Unfortunately, she is very functional from a physical point of view, but the stress triggers seizures. For example, the last thing I saw is she had a seizure, I think, at physical therapy. She fell and injured her knee, had to go get an orthopedic evaluation. So she's had multiple falls due to seizures that have resulted in orthopedic injuries. But she is ambulatory. She can get up. It's just she is afraid to be around people. She has some, that's the PTSD, some degree of agoraphobia.
Is that true even with her own family members too?
No, sir. I mean, she's fine with her. That's why the caregivers are primarily family members.
Thank you.
Oh, of course.
I have a question. It says here in 9744 that if it's an unusual case, they can order a lump sum in whole or in part. Was there any medical testimony about how much that she needed all the money right now and that would make her stress go away, or just have some money in the bank account to make her stress go away? Was it the fact that she thought that it was going to zero every week, so maybe if the commission just said, we'll give you 1 month and it stays in the account so you know it's always there? Was there any medical testimony about how much would need to go into that account to make her stress go away?
Jill, the only testimony about from the doctors was that they recommended that it be resolved as much as it could be resolved. You know, you can't resolve the medical care. I think we're in agreement on that. So they recommended a complete resolution. Now, having said that, I think your question is, again, a very good question, because the commission basically said we can't do anything. And the statute doesn't say that. The statute says we could pay you a year's worth of benefits to give you resources to bridge these gaps. But they didn't do that. They completely said it's all or nothing.
And that's really the only issue that's before us today, is the fact that you think they misconstrued the law and that they didn't have the authority to do anything.
Yeah, they basically said,
Yeah.
we as a body do not have the authority to make an award because it would violate, because of the lifetime, you know, the benefits paid for life, or until she goes back to work.
So we're not deciding today whether she gets a lump sum, we're just deciding today whether or not the commission can, and let me ask you this, does the statute give if it's an unusual case, how much discretion does the commission have? Because the second part of the statute talks about discretion if it's minor, but the first one doesn't.
Well, the commission, under existing Supreme Court law, the commission has total discretion to determine payment of future benefits.
As long as it's an unusual case, and that's how you construe this.
No,
Well, at least in this statute, if it's,
well, and I was going to point out that 9718, because the commission says we don't have a fixed period of installments. So made me go back and look at what are installments. And the Act doesn't define installments.
Isn't it based on a weekly wage?
Well, actually, installments comes from 9718, which says that compensation will be paid in weekly installments. And then it goes on to state, or such other period as the commission orders. It can go to weekly, monthly, and then it has a provision that says, or other periods authorized by the commission. So 44 and 18 are consistent and match each other to say the commission has total discretion as to how the benefits are paid.
But the amount is determined by her wage.
Yeah, the amount is determined by statute under the 97.2 average weekly wage, the definition of average weekly wage. So again,
So there's no discretion in that, correct?
I'm sorry?
There's no discretion there.
No, sir.
As far as the amount.
That's a statutory amount and defined by separate statute. Here, as Judge Dillon has pointed out, what we're trying to decide is, does the commission have the ability to, A, issue a partial award, or B, can they use General Statute 8-46 and figure out the life expectancy, which will give them a fixed period that they wanted. They chose not to apply 846. And 8-46, again, adopted by the legislature,
Right.
clearly states in situations where a determination of life expectancy is required, you apply 846. And that's exactly what this court did in the Johnson versus Southern Industrial Constructors in 1998. When they were faced with that question, I know Mr. Wooten is going to say that case was reversed by the Supreme Court, and it was reversed solely on the issue of jurisdiction under 10.2J, the lien statute. The Supreme Court never said that the Court of Appeals determination as how you calculate lifetime benefits is flawed. They could have said that, but they didn't say that. And so what this court said was, in cases of permanent disability, the calculation of future benefits expressed by the court's findings may be accomplished by multiplication of the employee's weekly benefits by the number of weeks the employee is expected to live, based on the tables, and other evidence presented. And in that case, they said discounted present value. 44 does not permit discounting. And I think that's really important, because I look at this case and say, the commission has total discretion what they can do under 18 and 44. Yes, there are no prohibitions against lump sum awards for lifetime cases. 9729 was created back in 1929. So was 1944. 1944, the 29 was revised in 1973, and it went from 400 weeks to lifetime benefits, and that's the first time lifetime benefits became an issue. And then the legislature amended 9744 2 years later. So you would think if they just awarded lifetime benefits and 44 is potentially prohibited from applying to those lifetime benefits, the legislature would prohibit that. But they didn't. The only thing they did in the amendment of 1975 was remove a requirement that the parties come to an agreement on a lump sum. So again, I feel that this court had it correct back in the Johnson case that the legislature has given us the tools to quantify a lifetime claim. Now, the question is, does the commission ignore that when the legislature has already handed them that tool and say we can't do that? When it comes to the issue of its lifetime, or they might go back to work, I think it's the same thing. The legislature created these opportunities for defendants to come forward, present evidence. So, for example, 9729, it says you get benefits unless the defendants come forward with a preponderance of evidence that this person can go back to work. So they have there's an out there, but defendants have that burden of proof. And in
So is it the defendant's position, are you saying that it's the defendant's position that if it's a lifetime type award, this statute doesn't apply at all?
which statute?
44.
Yes, sir. I believe that's
Well,
exactly what they're.
isn't the second part of 44 is a minor who gets disability injuries, permanent disability, isn't that a lifetime award?
Yes, sir.
Then okay, I'll have to ask the defendant that, because that, to me, clearly says it does apply, because it gives you an example of, the very example it gives you is the minor.
Yes, sir.
That's a permanent award, so.
And I would agree, and I think that the steps taken by the legislature in amending this, again, this is a situation where there are two statutes, 9729, 9744. Neither one of them has a specific prohibition about a lump sum payment under 9744. However, two negatives equal the commission deciding that there is a positive prohibition against lump sums.
Well, now, on conclusion of law 3, it's on page 58 of the record, where they're citing 44. And they have italicized, but in no case to exceed the uncommuted value of future installments which may be due of this article. Isn't that in and of itself a qualification or limitation?
I agree, it's a limitation, but only as it applies to the life expectancy, because 29 provides installments for life. Okay? So when you apply that to installments, it's installments for life. How do you value installments for life? The legislature has created 8-46 to do exactly that.
So you're thinking that it can be actuarially determined?
I do. And I also think that under 8-46, the defendants, if they were to argue this is a prejudice to them, that they're going to have to pay all this money out, they have the opportunity under 846 to bring forth evidence as to diminished life expectancy, things of that nature. So, but again, in this case, that didn't happen. There is no evidence in front of the commission.
Go ahead. Answer this question. I'll just finish the answer.
I think, Judge Tyson, did I answer your question?
Yes, I just want to make sure that, there appears to be a limitation in the statute that if you're going to do a lump sum, it cannot exceed the, quote, uncommuted value of future installments which may be due.
Yes, sir, and I agree. And the question becomes, what is the value of the future installment?
What if you can't determine that?
I'm sorry?
What if you cannot actuarially determine that?
Well, number one, the legislature has published 8-46, which the courts have accepted as evidence of life expectancy. So absent, as I read the cases, absent something else, that is the evidence.
Did you present the evidence of what that lump sum should be?
Yes, sir, we did.
And was it based on her average weekly wage?
It was based on her, we followed this court's calculation in Johnson and said, what's her life expectancy? How many weeks does that equate to? Multiplied by her average weekly wage, and it was, I forget, $1 million some dollars. Okay, I don't have that in front of me, but we did exactly that. Again, if defendants had presented some evidence through actuaries or whatnot, and I see that I'm getting into my rebuttal time, I'm happy to answer your question. But defendants didn't bring any evidence. They just basically came out and said, this cannot happen.
Would their obligation to provide medical care to her continue notwithstanding the lump sum?
Absolutely, yes, sir.
Okay.
But the lump sum would afford her the opportunity to pay for that when necessary to minimize those stressors that trigger the seizures, the migraines, and the post-traumatic stress disorder.
Is she keeping her own books? Does she pay her own bills?
I believe her husband pays the bills.
I did have one question I wanted to ask you.
Yes, sir.
The statute says that the commission may, or the industrial commission, you can get a lump sum where the industrial commission deems it in the best interest of the employer, but it says only in unusual cases. Is unusual cases a question of law that we decide, or is it up to the commission to decide what is an unusual case?
I believe the
What would you
very
say?
limited law on that is, that's a question of fact, and I think that's a question for the industrial commission, and we specifically appealed the fact that they didn't make that determination in this case. And the defendants are going to say, well, they didn't make that determination because they determined that they couldn't make an award no matter what, and therefore there was no necessity for a determination of unusualness. But I think that's a question of fact.
Okay, thank you.
I'll reserve the rest of my time.
All right, thank you. All right, Mr. Wooten?
Let me ask you, before you get started, let me ask you at the get-go, are you making any, because you won below, but you won below because the commission didn't think they'd had the authority under, because because the amount of the future payments is not settled. But did you make any, I didn't see any argument that you could have made a counter, like another argument saying, well, even if that was wrong, this isn't an unusual case. Do you think the unusual case part of the statute is a question of law or a question of fact? Or is it something you never didn't?
I think, Your Honor, I'm Patrick Wooten. I think, Your Honor, that is a question for the commission to make by the same standards that they make in every other case.
So you're not challenging that part of it?
I'm not challenging that part in the sense
Okay.
that they did need to make that determination, which they didn't actually, in the full commission opinion, make a determination of uniqueness. But that would be reviewable if there's any substantial evidence and the standards we have. They could review that. You could review that on that standard where they use their discretion. I don't think that's
That's an issue.
I don't think that's pivotal.
Okay.
I think you've hit the nail on the head here that the commission did properly determine that they could not make a lump sum award because the request to the commission in the briefing and in the case that came forward was a request for a total amount of indemnity to be awarded, not a request for a partial amount. There's some language about in whole or in part, but all the evidence that was put forward was you take the statute, you do the multiplication, and you come up with the amount, and you award it. But what the commission, I think, is rightly saying, and I think we've got two questions here from you, from Judge Tyson, Judge Dillon, about whether that is the determinative factor. And I think the defendants are arguing, and the rest of them, many of my colleagues would argue that that is the case because there is that uncertainty of what that amount is.
Well, I have several questions. The Freeman case, I just looked at the statute, and there's only 3 cases that are cited. Freeman v. Freeman, the court said, though it was dicta, awards for permanent disability may be paid in weekly installments or in a lump sum pursuant to 9744. The Montgomery case, that's where the beneficiary was going to get money, and the beneficiary was a minor. But in that case, that's a little speculative because if the beneficiary died before he turned 18, it stops. But you can get a lump sum there. And isn't that speculative too? And then 9737 talks about if you have an injury and you get a lump sum, you get several weeks of payment for like a lost whatever. If you die from an injury that's unrelated, it cuts off that benefit. So isn't any kind of benefit speculative in nature?
Not to the degree we're talking about under 44 here, I don't think, with the permanency. Under 31, when you've got the scheduled benefits, and you mentioned the minor part, it says partial or total. When permanent injury, its preface to that is permanent disability. And when you say total, it's a total loss of an arm or a total loss of a body part, I think is where the total is coming from in that language. Partial would be a partial loss of a limb or partial loss of a body part.
So when would 44 apply, I guess is my question.
44 would apply as it did in the Harris case, when you've got a death claim where you've got the benefits known, or you've got, as it's most often used, when you've got 9731 benefits that are definite. You know what the benefit is awarded for the partial disability for a back for another body part. You know what the weeks are that need to be paid
But
out.
if that person dies from a different injury that's compensable, doesn't that get cut off under 9737?
Not in those instances, Your Honor. I think that there's
I think
another
I
there's
think
another
9737 says that if you die, it goes to your beneficiary unless you die from something that's another injury that's compensable under the act, then that gets cut off and then you get this new benefit. So wouldn't it be speculative?
You would jump, well, that's the more municipal benefit for that person, because then you jump to a sum certain for the beneficiary of that. So the more municipal benefit under the act then, if the cause is from an injury or from work, the 500 weeks. So the beneficiaries then, instead of getting the balance of 31, would then get the 500-week benefit, which would be more municipal for them.
Mr. Wood, let's go back and talk about the standard of review. We're all aware of the typical standard of review on appeals from Industrial Commission is any competent evidence to support the award, but that questions of law can be reviewed de novo. Is this a deference standard of review, or is this a de novo standard of
I
review?
think this is completely de novo in front of you on the question of law as to whether this statute applies.
Should any deference be given to the decision of the Industrial Commission interpreting its own statute?
I think it should be respected, Your Honor, because of the amount of focus that the commission has on these matters and experience they have with them. There's a reason, I think, that and the defendants think, that there is such a lack of case law applying it in the manner in which the plaintiff would like this to be applied. It has always been understood, and I think the statute is understood correctly, that you need to know the value you're talking about before you can talk about an uncommuted value.
Well, we know what the average weekly wage, that's not disputed, is that correct?
That's correct. We know
And we know how old she is.
we know how old she is.
And it isn't, under Johnson, isn't just a simple multiplication of those two factors?
No, Your Honor, I don't think so. I think, first of all, I don't think Johnson is good law. I'd still maintain it's reversed. The Supreme Court reversed it, and if you look at the very beginning of the opinion from Johnson, it says that, and thus the trial court by this methodology had jurisdiction when this court was trying to use that as the method to obtain jurisdiction. So the reversal was not a remand. It was a complete reversal. So I think anything in Johnson is even if it's dicta, I don't even know if it's even dicta.
Well, there's a number of statutes and cases that all talk about the method of computation, correct?
For
For the average
yes,
weekly
yes,
wage
Your
against
Honor.
the expected,
there are at least 5 methods.
right. So again, why is it so hard to determine this woman's life expectancy, or is it?
I think it is hard because instead of dealing with, it's not like damages in a liability case, where you've got ongoing jurisdiction in a workers' compensation case. Her claim will continue to run and does continue to run because the medicals continue to run it. The commission at any time can come in and contain the jurisdiction to address issues with the case. It's not like a trial in front of a superior court judge where you are making a decision about what the damages are, and then this court reviews them, or the Supreme Court reviews them, and it's done. This goes on and on and on, and it's your point about that is, that's why the commission, what happens if she has too little money? What happens if she does die and the defendants have paid a greater amount of money? We've got a situation right now in this country where lots of people are dying unexpectedly outside of work. It's the uncertainty, and actually the legislature addressed the uncertainty in permanent and total a few years ago when they changed the act so that you could come back and see if there was an improvement and someone could gain employment. So, it is a legislatively directed mandate that you can not exceed the uncommuted value. And I still don't think that that the evidentiary statute and mortuary tables are sufficient for that, because if you look in Gilligan and some of the others, they were talking about all the comorbidities that would go with it to consider it when they didn't allow its use in that case. In his reply brief, the plaintiff is arguing that the defendant somehow they have a presumption and the defendants have a shifting burden to put on evidence that it's something less than the tables. This is a request for a lump sum by the plaintiff. This is not a request for a lump sum by the defendants. It's not the defendant's burden to put on what the amount is and to rebut that amount.
What does the words, the uncommuted value of future installments in 44, what does that mean to you?
To me, that means you take something like the 500-week death benefit, or you take 9731, where you've got 300 weeks for a back, and say you've got a 50% rating to the back, so you've got 150 weeks. Maximum medical improvement is the date you start. Whatever time it's approved by the commission, that's due in lump sum because it's accrued, and then the balance of those weeks are paid out weekly. Someone comes, makes an application and says, I would like the remaining weeks of my back rating, of the 150 weeks. The commission approves it, and it's paid out the remaining weeks, or
All
may
right,
come due.
if you use that definition, Mr. Wooten, how would that ever apply to a permanent disability for the remainder of someone's life?
I don't think it could, Your Honor. That's the point the defendants are trying to make, that we don't know what that amount is.
Then why does the last sentence of 44 talk about a minor who's been permanently disabled and you can pay the uncommuted amount for there? I mean, that's where I'm stuck. What did the legislature mean by that if they didn't mean for it to apply there?
That's what if you look at the language on that going into it, and this is what I was saying a while ago, I think I have gone a little astray on not clarifying that. If the minor who's received permanently disabling injuries, either partial or total, what the partial or total is qualifying the permanently disabling injury, and that's back to the body parts. If you lost your entire arm, you would get the rating for the entire arm. If it's a partial loss of the arm, you would get the partial rating. So the 50% to the back, or I suppose you wouldn't lose your whole back, but
Or total.
or total. So if you have 3 weeks, so it's the total amount of the permanent disability that's allowed under 9731.
And of
Well, I
course,
see I mean, I can see how you can read it that way, but the language of the statute doesn't really limit it. It says, it's, I guess the thing, I'm just looking at the language of the statute. And the language of the statute doesn't limit it to the cases that I understand it's been traditionally understood as applying to. It says that the commission may, and it limits it to unusual cases, whatever that is, if the commission deems it to be in the best interest of the employee or dependents, or where it prevent undue hardship on the employer without prejudicing the employee, that it can be done. So the plaintiff in this case is saying, well, this is unusual, although the commission didn't address that. But let's assume it's unusual for purposes of argument. And let's assume the commission deemed it to be in the best interest of the employee. I'm just trying to figure out where the limitation is that it couldn't, or the commission could, in fact, it says in whole or in part, which would kind of address the issue that you have as far as, okay, we don't know how long life is. Let's say that the commission said 5 years of benefits, just to be, so that there's a cushion. Why would they not have the discretion to do that under this, based on the language of the statute?
So Mr. Raymer brought up a point about 9718, talking about the commission may set the amount of the payments, either weekly, monthly, or some other term.
Mm-hmm.
So there's a provision, you say, commission, let's say that the commission sets it at 5 years.
Mm-hmm.
That would seem a more 9718 amount. I mean, the question we have before us here, and the commission had before us, was the whole. What is the whole amount to be awarded as a lump sum? My question back on that point would be, if you award 5 years, what are you awarding 5 years off of? what's the balance that's left? You still don't know what that is. You're just picking 5 years, or you're picking, that's why 9744 is not the appropriate vehicle to do that, if that was what one wanted to do.
Well, I mean, it does say in whole or in part, by payment of a lump sum which shall be fixed, in no case to exceed the uncommuted value of future installments. So, I mean, I understand it's just, you know, the statutory language we've got here is kind of squishy.
It is, and, you know, when you've got a statute that has not come up here quite often, you know, 97.2 we talked about has a lot of case law about how you calculate the average weekly wage. We don't have that benefit here. We've talked about that among ourselves and said, you know, what does the whole or in part mean? And among practitioners that I've talked to, that sort of goes back to when you're talking about 9731, and you've got an accrued benefit from the time it's approved, from MMI to the time it's approved, then you have a in part left. You don't have a whole left. So you can award the lump sum of the part. And we think that is probably what was the intent. Now, that is, like many statutes in the compact, it's not the most artfully written, but I think it's the most practical explanation of why it says in whole or in part. Because it's not uncommon. You get a rating, you get a second opinion, you come and you agree on what that is, you get that amount, and by that time, you've passed MMI for some period of time, and then there's the balance left. So that we think that in part is that part of it.
Mr. Wooten, on the uncommuted value of future installments, as it relates to a juvenile, you would never have an average weekly wage there, would you, to determine? Because they, by definition, are minor. So would that not be computed based on the loss of the specific body part, or?
Well, there is a catch-all provision for the minimum comp rate of $30 under the Act.
That's
you know,
per day, or what?
per week.
Per week.
And it's also the same amount for prisoners, and for, you know, so it's, it is the minimum amount under the Act.
So that's kind of a catch-all floor, if you want to call it that?
And it also happens sometimes with cases for us, for DPI, is we have substitute teachers who come in, and the minimum comp rate applies to them because they just don't work enough to have a rate higher than that. So it's not uncommon to have a minimum comp rate.
And it's 30 a week?
Yes, sir.
So that would be the rate that would apply to a juvenile with no average weekly wage then? as a
I'm not
floor?
going to say that authoritatively. The state usually doesn't work many minors. The only example, I've tried to think about which one would have a minor. I think maybe the PAGE program might be the only ones I'd ever have to worry about. So,
Well, what about someone in a youth facility? Wouldn't that apply to them?
typically, they are not working and getting paid. I think there's a reward system somehow, but it's not true monetary payments for them, I don't think.
We're going back again to the standard of review. It says the commission may, in unusual cases where the commission deems. Isn't that a wholly discretionary ruling? And wouldn't at least we would apply a abuse of discretion standard to their decision in that case, or not?
Applying abuse of discretion in that they abuse of discretion by not determining whether it was union?
No, by saying whether or not they're going to allow a lump sum. If it's may, in usual cases, deems, those are subjective terms. They're not objective terms, correct?
They are subjective, and I think that only kicks in if you're talking about a known lump sum that's some certain. Then you can look at whether discretion is abused. In Harris, she wanted to pay her house off. There are all sorts of reasons. People come and make applications. There's even a form for it at the commission of 90s. It's Form 31, I think, where they make an application of saying, these are the reasons that I would like to be paid in lump sum for my rating, why I want the balance of it now.
And what was her basis of compensation? Harris, was it a death benefit or?
A death benefit. There was no ongoing medical in that claim, obviously, but and unlike in this claim. And the idea in this claim that plaintiff makes about, well, I could just pay for my meds and then presumably that implies get reimbursed, but the compact isn't structured that way either. because medications and there's a fee schedule for treatment. The employer directs care. You can't just say, well, I'm going to run down to the doc in the box and get X kind of treatment and then make a presentment. A lot of the stressors in talking about in this claim have been stress with medical care as she perceives it, which will continue on. That won't go away.
And the attendant care services she's receiving, those are also, would continue notwithstanding the lump sum?
Correct.
Are they not medical, quote, medical expenses?
They are medical expenses, Your Honor.
Was the death benefit paid in that case based on the fact that the person died, or was it a beneficiary benefit that a beneficiary gets?
In Harris, she was the widow.
So she gets, I mean, does she get benefits for being his widow? Is that the benefit, or is the benefit?
She is it's a common misperception that it goes to the estate, but it is the beneficiary, so she would have been the whole, I don't know the case.
And it gets
well.
paid weekly?
She was the whole beneficiary under the act that would take. Yes, it is paid weekly. If there are weeks that have accrued since the date of death, they would be paid in lump sum up until the date the first payment is made.
And how long
then
are they paid
weekly
for?
thereafter.
How long are they paid for? Is it a certain number of weeks or until she dies?
It is a certain number of weeks. Under the current act, it is 500 weeks of benefits for someone in her position.
So when she dies, where does that money go? To the next account?
Stops.
It stops.
It stops.
So then in Harris, it was not a sum certain, because we don't know how long she's going to live for.
Her benefits stop, yes. Yes,
Well, then
but-
how
but
was she entitled to a lump sum in that case if her benefit, she could have died the next week and gotten all this money and paid her house off?
Unlike this case, there was a sum certain to be known.
You just said it wasn't. If she died, it stopped.
It stops.
Okay,
True,
so
that's correct.
it's not certain. We don't know how long she's going to live for.
But in that instance, she had a known number of weeks. It's not the fact that it may stop. What we're arguing here in 44 is that you can't set with certainty the amount because you don't know the amount at all. In her case, she had a finite number of weeks left of her benefits. In this case, what Mr. Raymer is arguing is that you take the mortuary tables, multiply it by, use her life expectancy, multiply the average weekly wage, and that's your amount.
Whether they live that long or not.
Whether they live that long or
And in
not.
Harris, you take the workers' comp statute and you take that statute, whether they live or not. So why is this any different? You're just using a different statute to set the number of weeks. They're using 8-46. Here you're using, 9721 or whatever sets the number of weeks, which could be cut off by the death of the person, I guess. I mean, why should we apply this differently? Just because in both cases it could be cut off and you can't know. We know the weeks here too, because you have the actuary table. It's an arbitrary number, but so is the workers' comp statute. It's just 500 weeks, but it can be cut off. Actuary tables is arbitrary, but it's a rule of evidence that says it should be used if there's no other evidence.
I think that goes back to the injunction being read with the permanent and total provisions about the possibility of someone going back to work. I think you've got to read those in harmony. I don't think it's quite as clean cut as that.
Well, the statute also says that the commission has an obligation under 44 to, quote, prevent undue hardships to the employer or the insurance carrier. So basically, if you pay out a lump sum based on lifetime benefits and the person dies a month later, I mean, would that meet that statutory test?
I think Mr. Raymer will tell you it's a disjunctive or. I think it's in his briefs and his argument. There's a disjunctive or in there. But I think in our brief, we point out that there are a number of provisions in the Act and interpretations that this court and the Supreme Court have made that you must read the Act in harmony, and it is for the benefit of both parties involved and not solitary to one side. In that case, it would be a violation under the case law if something like that happened. And I think that's what it's intended to prevent. Basically, in many ways, if you've got something if it's not perm total when you come and it's 6 weeks have gone by and someone says, hey, I plan to be on comp for a while, can you give me some money? And here's the amount. I plan to live for a while, and here's my life expectancy, and I'm not sure I'm gonna make it that far. How about giving me some money now? I mean, under reading and interpretation and putting the mortuary tables together, could the commission do that? I mean, that's what basically, it's not just about Ms. Blackwell's case, it's about every other comp case that's ongoing. And if you've got insurers who are writing a case and someone might come and say, hey, I think I really would like my money now. There's a provision for that, and that's 9717. You get together with the employer and you settle the case. That's what the legislature intended for that. Not 44 and coming up with a number and assigning it in an unknown amount. That's not what this statute was intended for. 9717 was intended, if you want to settle your case and you want a lump sum of money and you want it right now, then you come together with the other side and you form an agreement that the commission deems proper. There are review processes for it. And that's how you settle your comp case.
Okay.
That is not 9744, it's 9717. That's the legislative intent, looking down the road of how you deal with that. If there are no further questions, I think the commission was proper. I think the ruling is correct. I think the application of 9744 in this case would be inappropriate. And I think the commission has gone this far applying 9744 correctly. And I think we can keep on applying it the same way. And the jurisdiction will continue in cases such as this. And
Let me ask you, I want to hit, because I don't have 17 in front of me, and I should have read that a little bit closer. Does 17 apply, what type of cases does 17 apply? Does it apply to cases where?
all cases.
All cases?
All cases in front of the commission.
So you
Including
can
this
settle
case.
anything. So even in the case you think 44 applies to, you said 44 applies to, like, if you get 200 weeks for a broken, whatever. So you could under 17 go ask for the lump sum if you want to.
Under 17, no, 17 is the statute that allows the parties to come together and compromise and settle the claim.
For any kind of claim. Okay.
Yeah, it's why we mediate all the time. It's the mediation statute. It's when we come together, we say, hey, you say, I think my case is worth $1 million. I say, I think it's worth $5. You know, and everybody, it's the old saying, everybody goes home unhappy. I paid too much. I got too little. And then the commission approves it. But it would resolve, you can resolve in whole or in part there. You don't have to resolve the medicals on a claim. You can resolve the indemnity portion. The commission will approve clinchers, as they refer to them, as just the indemnity portions and leave the medicals open. Now, sometimes the employer doesn't want to do that, and they don't have a meeting of the minds, but you can do that, and it's done quite often. So that's the remedy if you want to settle your cash out on your unknown amount of indemnity, because that is speculative. Both parties are taking a risk there. That, you know, okay, well, how long is this claim going to go on? I don't know. What are you willing to pay? What are you willing to take? I mean, that's the legislative intent. That's the way it's come forward. That's why we've got a lot of case law about settlements. So now we have conditions where, of course, we have to consider Medicare's interest, Medicare set-asides when we're settling medicals. Those come in, get involved, it gets a little complicated, but otherwise, that's the mechanism. Any further questions?
No, but thank
Okay.
you.
Thank you.
And I'm going to ask if this correctly reflects my time.
Yes, it's
Okay.
5:33.
Thank you very much.
Yes.
Let me address a couple things Mr. Wooten said. 17 versus 44. 44 used to say the parties could agree until 1975 when the legislature, the amendment, deleted the parties agree. So specifically, 44 took out the requirement that the parties agree. Apparently, that goes over into 17. But if you think about it, 17 says you can either agree or not agree. Well, if defendants say, we're never going to pay you, 44 provides the opportunity for the commission to decide what's the best remedy, okay? And so 17 goes to agreements, but 44 provides the commission the authority to say the best result for this person is a lump sum. And that's why the commission makes those decisions in fixed schedule awards under 31. But let me just make that distinction. In this particular case, and this goes to Judge Stroud's comment, there's no language in the two statutes, or the three statutes that apply. 9729, the lifetime award, specifically does not exclude application of 9744. Subsection E, when the legislature redid this, and this was redone in 2011 in a 20-page amendment, of which 2 pages dealt with 9729. They didn't amend this part, though. Subsection E says the employee shall not be entitled to benefits under this section or GS 9730 or GS 9731 at the same time. So the legislature specifically wrote into things that don't apply. But they didn't put 44 in there. They didn't say, they could have put 44 and said, 44 doesn't apply because now we've amended the statute to say unless the defendants bring forth evidence. And the legislature didn't do that. Under 9744, there is no specific prohibition against a lump sum award in a lifetime case. And as Judge Dillon points out, the end of that section deals with a minor getting lifetime benefit, essentially getting benefits. So how is that different? There is no, the statutes on their face just don't have the prohibition. And then you add to the fact that the legislature created 846 specifically, and in this statement it says when it is necessary to determine life expectancy, this is what you use. That's the legislature's specific intent right there. The legislature did provide the opportunity in 29 and 44 for the defendants to come forth with evidence to effectively try to not, totally prejudice them. So in 29, they could come forward and say, hey, this person might be going back to work, or there's some evidence. In this case, that is not the case. There's no evidence.
Let me ask you a question. Let's assume that the benefits are $50,000 a year and the actuary table says 20 years of life. That's $1 million. Can the commission discount that by an appropriate discount rate if they want to?
They act specifically under Lee versus Harris paving, they cannot. The court's already ruled on that.
No, the statute only says
Well, actually,
cannot exceed that amount.
Well,
Do they have why don't they have the discretion to discount if they want to? Just can't exceed it. That's all that case said.
I
They don't
agree.
have to discount it.
I agree with you.
Okay.
Totally.
That's how I just make sure.
The commission could say, in the interest of the parties or whatever they want to do, if they can justify it without abusing their discretion, do that. They could
Set a
clearly.
3%
They could
discount
have come in
or
and said, we have a lifetime, a 500-week cap until you get extended benefits. We're going to pay that. But the point here is the commission said we can't do anything. And we would contend that that's just an error of law, that they have created a restriction where none appears, and that we would simply ask that the matter be reversed and remanded back to the commission for further determination as to what is the appropriate lump sum, if any. I mean, they could deny a lump sum. But again, defendants get to put on evidence, and the commission decides. And let me just address the Harris case, since I have one final minute. If you look at that case, the court basically said, what's going to provide this person the best remedy? And realizing that the income is a stream of income to make sure that they do not become financially destitute. But then they also looked at the better remedy was to let this person pay off their house so that they wouldn't become physically destitute and be homeless, because they would be working into their 80s or 90s. And so the court said, that's how they got to the unusualist part. And that's kind of really where this is. The commission needs to make a determination, is this lady's life from the next 30 or 40 years to be stuck in this system where she can't, everything she gets, as her husband testified, she feels like she's on a dog leash. Every time something doesn't happen, they're jerking her again. And that's what triggers her seizures, that's what triggers her migraines. We think the commission has the authority to do that. We think the statutes are very clear on their face, that you have to interpret them outside of the specific language of the statutes to reach the result the commission did, and therefore we would ask that it be reversed and remanded with further instructions as appropriate. Thank you.
All right.
Thank you.
Thank you very much for your arguments. Y'all ready? Go with the next one. I would assume. Let's see. Okay. And our second case for argument today. Go ahead and set up. Do y'all want to take a break?
Hall versus.
Huh? Mm-hmm. All right.
Thank you.